This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. We're in this together.
City of Tempe. We are in this together.
Hi, everybody, and welcome. We have a couple questions. So the first one is, says, an individual requested permission to add a strip of concrete perpendicular to their steep driveway. Their senior father lives with them and has had a difficult time holding the door open long enough to exit the car. Several additional expanses of concrete by driveways have been approved in the neighborhood. There is no restriction on this addition in any of the governing documents, and no additional paperwork has been asked for by the association. However, in this case, the homeowner was asked to provide medical information for the senior living in the house. This individual did not submit the request or owns the home. The owner did not want to provide this information due to HIPAA, and thus was denied the additional concrete. Can the association ask for medical information on a family member who does not own the house or is a member of the association? Can they deny this request even though it was approved for other homeowners? So it sounds like we have a homeowner who's wanting to put a driveway addition into their property. And I guess it's hard for me to comment on this without seeing the CC&Rs, right? But we have a good cheat sheet on this. As we already talked about, our federal laws cheat sheet, which can be found at mulcahylawfirm.com on our cheat sheet page. We also have a blog talking about making reasonable accommodations for owners. I guess here's the bottom line. If your association's documents give the board discretion as to whether or not to add or to allow an owner to add, concrete perpendicular to a driveway to allow for additional parking, it is in their discretion. And so you have to look at what the CC&Rs say. If you're wanting this because you have a resident in your home who's disabled and they need it to park there, the association is well within their rights to ask you for more information about the disabled resident and to ask for a letter from their doctor. Okay, the next question is, our HOA may need to amend the CC&Rs. Our CC&Rs limit updates to once every 10 years on a 10-year cycle. I recall a statement by your firm several years ago that an ARS update has eliminated this limitation. Is this correct? So basically, you're asking, you need to amend your CC&Rs, and it limits the updates to once every 10 years on a 10-year cycle. So yes, there is legislation that would allow you to, now amend your CC&Rs pursuant to the amendment provision in your documents, and you wouldn't have to wait for the 10-year cycle. So if this person would like more information on this, you're welcome to contact our office. Contact me directly at Mulcahy at mulcahylawfirm.com. Some of you may know that our firm offers a free 15-minute review if your association is thinking about amending your documents. And so this particular person who's asking this question should definitely consider taking advantage of that free CC&R review. And we can talk a little bit about the amendment procedure and what state law says and how you can amend it underneath your documents. And so bottom line is that 10-year cycle that your association requires, I'll have to look at the language specifically, but there has been legislation passed that would allow you to amend it sooner than that, as long as you follow the amendment procedures as outlined in your documents. The next question is, we're an age-restricted community. How can we enforce it when we suspect someone has children living with them? I think the best way to handle that is to reach out to the owner and find out what's going on. Who is occupying your unit and see your lot and see what they say. In a 55 and over community, at least one resident has to be age 55 or over, and your documents will specify how long somebody who's underage can be living there. Be careful if there are extenuating circumstances, like if it's a handicapped child or something like that, because they may be protected under the Fair Housing Act and be allowed to live there. So I would suggest as a starting point, reach out to them, find out who's living in the property and how long they've been there, how long they're planning to stay, and then reach out to your attorney to discuss what your options are. Next question, I've asked one of our directors to take pictures of properties needing weed cleanup and to send to me. Is this a violation of any kind to their privacy? I would say as long as you're not entering anyone's property to take those pictures, it shouldn't be a violation of the owner's property to do that. Many associations have, either management company employees or board members who, find violations and snap photos of them, but just be mindful not to trespass on that person's property. Next question, number 5, is my association's CC&Rs require each owner of a property shall pay a $2,000 capital improvement fee to the association at the time of purchasing a property. Does this language create an enforceable legal obligation that is always the buyer who must pay this fee at the closing? What happens is lots of times these fees are negotiated between the buyer and the seller. And so, you should just know that that's how this works. The association doesn't really care who pays it as long as it is paid. Next question, number 6, our bylaws state if you're over 15 days behind in assessments, one cannot vote. At the last annual meeting, the management company said if they mailed out a ballot, it had to be counted even if the homeowner was in arrears. Which does the board follow? Okay, so this is a good question. This does come up. So it depends. Basically, it depends on how your association, handled this before the election. So if you indicated on the ballot or you indicated, by contacting the owners that were delinquent that your vote will not be counted at the annual meeting pursuant to the section in the documents that allows us to suspend it, and you took all the necessary things that you needed to do. Some associations, allow these owners to have a hearing. If it just really depends on what your documents state. But so if your association announced that delinquent owners weren't going to be allowed to vote, then you can tabulate their ballot for quorum purposes, but you don't count their vote for maybe the election of directors or removal of a director or whatever the special meeting of the membership vote is or the annual meeting vote is. If you don't follow that procedure, you really do need to notify owners that they're not going to be allowed to vote, and then state the section in the CC&Rs. Otherwise, you won't be able to do that. Okay, what is the best format to advise current management company that the board has selected a new company? 30 days notice per contract and a 30-day overlap transition period. I think the best way to handle when you're changing from one management company to another is to just be honest. Just say, we have decided to go in a different direction. Let's make this a very professional transition. Word always gets out. If you're looking for a management company, sometimes I think the management companies talk if they, know that one management company represents an association, and they may call the current management company and say, hey, heads up, your association board is looking. So my advice on this is the word typically gets out. And so what you might want to do is just be honest and straightforward and just let them know, we appreciate everything you've done for us in the past, but we are going in a different direction. And just, this happens in our industry all the time. So, hopefully everybody can be professional and nice and move on. But the best format, just so you also do need to look at your contract, because if your contract may also have a specific procedure on how you tell your management company that they've been fired. So look at the current management company contract. You may have to notify them that they're fired, by certified mail or by mailing it to a certain address. Next question. I have an HOA that just started managing that has in the bylaws that board members do not have to pay their annual assessments. This association bills one time a year, and I'm told that board members get billed, but then they receive a credit after the annual meeting. Is this legal, and is it okay for board members not to pay their dues because it's written in the bylaws? I'd have to see the provision in the bylaws to weigh in on this, specifically. But my initial feeling on this is that it does not seem like it's a good idea. And although it does allow associations to receive compensation if it is written in the documents, we may really want to take a look at this issue and see if it's something that is a good idea for your association. So I'm going to just give you kind of a question mark answer. I need to say what it says in the bylaws. There is a provision in the Nonprofit Corporation Act that allows board members of a nonprofit corporation to receive compensation if it's in their documents, but I have to see specifically what's in your documents. And also, I would just like to state that most associations, 99.999% of them, do not compensate their directors, even if it's just in this indirect way of a dues elimination. They don't do that. Okay, next question. Is the Arizona Legislature considering any additional laws related to political signs and flags that might be passed prior to the 2022 midterm election? Okay, so we already talked a little bit about the one today where political signs can, now be placed on the property up to 71 days in advance of the election. And then 15 days after the election, they can still keep the sign up starting September 29th. Do we think there's going to be other possible, restrictions or limitations, or maybe even lifting of restrictions? Possibly. What the best thing you can do is make sure you're following us on Facebook. Make sure you're checking the homepage of our website when the legislature is in session in January of 2022. Every week when the legislature is in session, we are giving a free update, and it's listed right on our homepage. And when the legislative session is over, then we put out a summary of what has been passed and signed by our governor. Is it possible if we have a short legislative session next year, or maybe even if the bill has an effective date that's earlier than the general election in November 2022? Yes, it is possible that there could be some legislation. I'm not hearing any grumblings or whispers about that, but anything's possible when the legislature is in session. Next question. If a member of a community wants to amend the CC&Rs, is there a manner in which this needs to be presented to the board before requesting a vote to implement such amendment? So a homeowner wants an amendment to the CC&Rs. What's the process they should follow? I would recommend that the owner go to the board with what they want to propose to amend and try to work with the board to, get legal counsel's input on the language and then to send out the amendment for a vote. That's the best way to do it. I have seen other circumstances where an owner, just tries to do it alone. It becomes problematic because what they might be proposing may not be clear or might violate state law or something. And so really try to go the route of working with the board to implement that amendment. Will allotments regarding water rights vary if communities have reclaimed water sources for their turf? That's a really great question. I don't know the answer to that. I would recommend that you reach out to the state of Arizona Water Resources Department and ask them that question. What is the definition of an emotional support pet? Chicken, pigs, donkeys? Okay, that's a really good question. So typically we see the definition of emotional support pet to be a dog or a cat. I have not in 25 years seen a chicken, pig, or a donkey. Most association documents would require, to have a generally, like a common type pet to be an emotional support pet. I guess we'd have to look at each request as they come in. I'm doubtful that those would qualify or that a medical doctor would write a letter based on that, but we'll have to look at it if it ever comes in. Does a homeowner have to present proof of their disability? Is the next question. So yes, in the form of a letter from a medical doctor, just indicating that the person, has a disability. They don't have to go into too much detail, but enough detail so that we recognize that the disability is covered under the Fair Housing Act. How is the cost of removing an item such as a pool lift covered when the person is no longer in the community? So this is a really good question. We kind of touched on this when I was talking about the Fair Housing Act. So these are all things that should be discussed and decided and, placed into writing prior to the pool lift being installed, so that it's clear that if the association owner is paying for it, the association owner should maintain it. And if they don't maintain it, what remedies does the association have? If the owner moves, what happens to the pool lift, who pays for the removal, etc. But I'm thinking maybe your question is, how do we handle this if the person's no longer here? Really, it's just the board makes a decision to remove it and the board pays the cost if there was no prior agreement. Now, if you want to keep it or you want to upgrade it, then the board makes a decision to do that as well. If the CC&Rs clearly state what flags are only to be displayed, how can you say that other flags should be tolerated and are okay just because of these times? Rules are rules, just like the law is law. I think saying flexible is irresponsible. Well, one of the great things about having a dialogue and a question and answer thing is we get to hear opposing viewpoints. And I think just everybody has, a different viewpoint. What I can tell you is that based upon my experience, sometimes it is better to be a little bit more flexible, especially during the pandemic. We had to be flexible on a lot of things that maybe we hadn't done before, like using Zoom, which frankly is not something that is, envisioned by the open meeting law. And allowing certain political flags, even though, the law hasn't yet caught up to say that a political sign is a political flag. That's where the law is going. And so I'm trying to be proactive and not make you the test case in Arizona that will end up resulting in a lot of money being spent by your association defending it when someone questions whether the flag could be construed as a political sign, which I think probably it could. The Black Lives Matter flag is another example. If you choose to not allow this in your community, that's your choice. But there may be consequences in the form of negative press, or maybe your owners will be very angry, or maybe you'll start having protesters in your community. And these are all just things, these are your decisions. It's just my opinion based upon my experience. And of course, everybody's entitled to their own opinion on how they want to handle things. Okay, next question. Sorry about the little technical difficulty there. The next question is, can HOA limit just one sign for sale or for lease? In other words, you have front and back windows. Can sign be placed in each window? So typically, it is just one for sale or for lease sign and a rider that's allowed on your property under the law. Some associations allow owners to put it in multiple locations. It just depends on if your association's willing to be less restrictive than state law. Last few questions here. We are a gated community with private streets and no sidewalks. Are we required to make any modifications to the streets to accommodate the disabled if they were to move into our community? It's possible that you might have to make an accommodation. It just depends. If an owner asks for a modification, I don't know what it might be. It might be, technically you probably won't be able to build sidewalks. That's a pretty expensive thing. And I don't think the owner that's requesting it would ever spend the money to do that. But it's possible, if they're willing to pay for it, but unlikely, like I said. The more common thing would be to cut a curb in order to, be able to get to a certain area in your community. And you're gonna have to look at each one on a case-by-case basis. The next question is, our HOA has still not had any meetings since January of 2020. This includes no annual meeting. Financials are not available to owners. When asked, this request is a deferred perception, is that this equates a difficult owner. How can an owner be assisted? So you want to have board meetings. Your association hasn't had any due to the pandemic, and financials are not available to owners. They're making you out as a difficult owner and they're not giving you the information. You may need to either go to the Okay, so we were talking about if you have an owner who is requesting financials and to have an annual meeting, how do we get them to actually do that? Go to the Department of Real Estate, file a complaint. There's a charge to do that. Hire an attorney. There are a number of owners' attorneys who contact associations, and they are somebody who can write a letter to the association. But first, reach out to the owner, to the association again, and say, listen, I don't want to go legal on you, but I am going to if you don't have your annual meeting and if you don't start sharing documents with me. And if they refuse to do that, litigation, going to the ADRE, or hiring a lawyer to help you with this to get the information are all things that you have a legal right to do. Okay, is there a size restriction on for sale signs? Yes, I talked about it briefly in my presentation. The signs have to be industry standard sign, which which generally does not exceed 18 by 24 inches. And then the industry standard sign rider, is also required to be allowed, which should not exceed 6 by 24 inches. This section only applies to a commercially produced sign, and associations can prohibit the use of signs that are not commercially produced. Next question, where does the association post all of these rules, such as sign restrictions, open house times, etc.? What I would recommend is that you put them in your newsletter, on your website, talk about them at meetings, put them in communications to your owners. The rules also are provided to all, potential buyers through the disclosure statement. Just really any way that you communicate with your owners, you can add that to it. The next question, what is the association's responsibility when there are freestanding condo units that are 2-story fourplexes as far as structural issues? If one unit has a structural issue, is it the responsibility of the association to examine and repair? CC&Rs state anything inside is the homeowner's responsibility. Okay, so we have to determine, I'd like to see the CC&Rs, obviously, before I could ever render an official opinion on anything like this. But you have freestanding condo units, 2-story fourplexes, one unit has a structural issue. It really is just going to depend on, how, can you still pursue the developer? What do your CC&Rs say in terms of who's responsible for what? That's something that I can't answer, during this neighborhood services virtual seminar today, but if you contact our office, we can point you in the right direction, maybe get you in touch with the construction defect attorney if it is the association's responsibility. Next question, when the board notifies the homeowners that there are sex offenders living in the condos, can this be done in a newsletter or email blast, or does it need to be in a formal open general board meeting? You can do it in a number of different ways. Just be careful what you say. Stick to the script of exactly what the law enforcement agency notified you regarding the sex offender, and make sure that you make a statement that, this person cannot be harassed or, discriminated against in any other way. This is only being provided as notification. So you could put it in an email blast, you could post it on the common areas, you could just talk about it at a board meeting. Most associations don't have high participation at board meetings, so you may not be getting the word out if you're only talking about it at a board meeting. Next question, can ESA personal qualifying conditions be shared outside of board meetings, of board members? Is it protected by HIPAA? So can an emotional support animal personal qualifying conditions be shared outside of board members? Is that protected by HIPAA? Okay, I think this kind of goes to the question of confidentiality and board members' duty of confidentiality. If your board comes into information from an owner that they need a emotional support pet and the specific reasons why, my opinion is that you have a duty of confidentiality and you shouldn't be disclosing that to non-board members. What I would recommend is if homeowners are asking you, hey, why does this person have a dog? You can say that this person is entitled to a dog under the Fair Housing Act, and it is considered an emotional support pet, and we're not at liberty to say anything else. I think that's the best way to handle that. Okay, so we're closing up shop. As I said, this is our 8th virtual neighborhood services HOA Academy. So happy to be here today. I would say today's class probably had more technical difficulties than I've ever had, but I want to thank my team of Morgan and Yvonne for being here and helping us get through any technical difficulties that we had. Thank you for joining us here today. We had a great session, about an hour and 43 minutes where we were together. We covered a lot of ground today on hot topics pertaining to associations. And I'd like to just thank everybody for being here today and making your community better. And I'd also like to thank the neighborhood services from the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Scottsdale, Surprise, and Tempe for their teamwork, genuine teamwork, and combining together to create these classes to provide free content for board members, homeowners, and managers so that you can be better informed about the laws that pertain to associations and do a better job managing and working within your communities. Please consider joining our next class. We have our 9th class of 2021 on our virtual HOA Academy on September 14th at the same time, 11 o'clock a.m. And for more information on that class, you're welcome to visit us at mulcahylawfirm.com. We have all of our upcoming classes listed. I think we have 3 separate classes, plus our First Friday's virtual call-in. So we have 4 different opportunities for board members, owners, and managers to get free information on how to best run their associations in September 2021. So check out all this information on our website at mulcahylawfirm.com and click on our upcoming seminars tab. Have a great week, everybody. I look forward to seeing you all in September. Take care, everybody. Have a great rest of the week.